Court of Appeals Citation Policies. 1. Citation to the Colorado Court of Appeals of its own opinions, which are not selected for official publication, is prohibited. Hello and welcome to Unpublished Opinions, a short circuit podcast. This is the podcast where IJ attorneys talk about things other than the federal courts of appeals. I'm delighted to have with me two of our regular guests together with me for the first time on Unpublished Opinions, and that is Anya Bidwell and Diana Simpson. Welcome to both of you.
Thank you, Anthony.
Hey, fun to be here.
Now, we're recording this June 7th, 2024, Friday. Right now, Supreme Court opinions seem to be coming out Thursdays, although I'm guessing that's going to get a little more active later in June. So we're at a point in our lives where Anya's Gonzalez case has not come out yet. But when you're listening to this, that may have changed. So everything could be different. Now, the last Unpublished Opinions, we actually talked about the oral argument in that, and that was all fun. But we have a little window of time here where Gonzalez has not yet come out, but another First Amendment retaliation case has, and that's the case many of you might have heard about, the NRA versus Vullo case. And it was unanimous, as it wasn't terribly surprising, but it's another retaliation case, and we have our retaliation expert here. So we thought, we'll start off with that and see what she thinks of SCOTUS's latest work. So, you pleased? You reading any tea leaves in Vullo? What's it say to you?
I'm definitely pleased in terms of what Vullo had to say. I think that's exactly the right outcome. And I'm living in this ignorant bliss for now, where you have this great First Amendment decision come out. Yeah, and our First Amendment decision hasn't come out yet. And it's filling me with hopes. But of course, maybe by the time you guys are listening to this podcast, I'm no longer in this state of bliss, or maybe I am. The case is kind of a pre-retaliation case, right? They really haven't gotten there to the question of, elements of the retaliation claim. That's Gonzalez that's going to clarify that. What they're talking about is this threshold question, whether they stated a First Amendment claim by showing in their complaint, the NRA, that they that the New York government was engaging in coercion rather than persuasion. And it'll become clear as I discuss the facts. So you have this government official, Maria Vullo. She was the head of New York's Department of Financial Services. She was already investigating some of the insurance companies dealing with the NRA when a gunman opened fire at Marjorie Stoneman Douglas High School in Parkland, murdering 17 students and staff members. Following that shooting, according to the complaint, insurance companies in New York that were being investigated ceased doing business with the NRA altogether. According to one head of an insurance company who explained his actions to the NRA over a phone call, the guy said he had no choice, otherwise his company would lose its license. According to this other executive, Ms. Vullo specifically told him that the Department of Financial Services was less interested in pursuing these types of infractions so long as the insurance company ceased providing insurance to the NRA. So in other words, these kinds of violations were totally fine by the New York government if it wasn't the NRA, but if it's the NRA, then they're not gonna blind themselves to these kinds of infractions. There was also an official guidance letter that encouraged insurance companies to manage their risks by not doing business with the NRA. And there was an official press release from Ms. Vullo and from Governor Cuomo, kind of along the similar vein. So what the Supreme Court said is that facts, as alleged in the complaint, show that Maria Vullo engaged in coercion, not persuasion, when she essentially pushed insurance companies to cease their relationship with the NRA or lose license in New York. And so now that the court said you alleged enough facts to show that it was coercion, now they can proceed to try to prove their retaliation claim under the Mount Healthy standard, or perhaps even under the Nieves standard, and also that they would have to overcome qualified immunity. So this is very much of a threshold question, but a very important threshold question. When is that line crossed between coercing somebody as the government to do something versus persuading somebody as the government to do something? And as you mentioned, Anthony, the decision is unanimous. Congratulations to Eugene Bollock, the friend of the show. A friend of the show. I'm sorry, my article's always messed up. A friend, one of the many great friends of the show.
Well, we can call him the friend when we're talking about Eugene.
The friend of the show.
Or maybe the friend. Maybe there's a difference between the friend and the friend. Just
the friend.
A difference
I like
of
it.
emphasis on the wrong syllable.
I like it. I take that. He filed the petition that was granted, and then ACLU's David Cole argued the case. It's kind of showing that there is very much of a cross-ideological undertone to this. Can you punish your critics as government official? when
Even
you
the
don't
Solicitor
like
General.
what they have to say.
Yes, United
exactly.
States Solicitor General. Yeah.
That's exactly right. So you have cross-ideological agreement here that it was coercion, and you have a unanimous opinion, and you have a very interesting concurrence from actually two concurrences, really. One from Justice Gorsuch and another one from Justice Jackson. And Justice Gorsuch kind of emphasized something very interesting that the majority opinion said, which is that the government, when it looked at all these pieces of evidence that I listed earlier, they kind of just debunked them one by one. For example, they said, this guidance letter from the Department of Financial Services, we do this kind of stuff all the time. It doesn't really show anything. That was a normal operating procedure. And what Gorsuch said, and what the unanimous court also said, Sotomayor writing for the court, is that you can't just look at, you can't just isolate pieces of evidence and say, we can explain it this way. Oh, and this situation can be explained this way. No, you have to look at them holistically. And that's very encouraging, because Gonzalez is a very similar case in that we're showing that when the mayor and the police chief decided to punish Ms. Gonzalez for her speech, they engaged in all these various activities that together show that but for their animus, they would have never done that. And what the respondents argued in their brief was very much, we can debunk every one of these little pieces of evidence by calling them something else. But the court said you can't do that. Complaint states a holistic picture, and you need to look at it holistically. And then, of course, Justice Jackson, she said, here we are deciding the threshold question about persuasion and coercion. And now that they stated enough facts to show coercion, they have a heavy burden to overcome in this retaliation context. And that's where Gonzalez comes in, right? And Jackson says it's not an easy task. Even Mount Healthy standard, which is what we are arguing for in our case, even Mount Healthy standard is a difficult standard to overcome to show retaliation, because you have to kind of state causation. And that's what we also argued in our case. And again, respondents disagreed with us. They said, oh my God, if you have Mount Healthy, burdens of litigation are going to just open up and everybody will be able to do whatever the hell they want. And Justice Jackson made it clear in her concurrence, as well as Justice Alito made it clear in his questioning during oral argument, is that Mount Healthy is not an invitation to frivolous claims, that it's still very difficult to meet the requirements. And that's something that NRA will have to do. So NRA has a long fight ahead of it. It's just they met this threshold burden and then they can proceed.
And remind me of the difference between Mount Healthy and Nieves.
So there is an additional threshold question in Nieves involving probable cause, right? If there was probable cause for your arrest or maybe for an investigation, that's kind of an open question. Then plaintiff has to show that similarly situated individuals were not treated that way. And then once you meet that threshold question, then you go to the standard Mount Healthy test. Of course, what we are arguing in Gonzalez is that this threshold requirement really only applies to split-second decision-making or more on-the-spot decision-making, not just split-second, by police officers, and doesn't apply to desk-bound bureaucrats. But that's something that the court will wrestle with as it's thinking about
Would
Gonzalez.
Nieves even apply here because the NRA's fact is just not the same thing? There's no arrest. It's this third-party stuff.
Yeah, it really came up during the oral argument, and the answer is not clear. Some circuits actually look at it and say, Nieves is a better framework for this than Mount Healthy. And other circuits say, no, Mount Healthy is a better framework for this. And the court kind of, during the oral argument, it didn't seem like they were particularly favoring one side over the other. It's the kind of thing that the court basically said, we really don't need to go there. And David Cole was also very clear that you don't need to go there, although he was very eloquent in arguing why it's Mount Healthy and not Nieves that should be the primary precedent.
One of the things I really appreciated about Justice Gorsuch's concurrence and kind of what seems to be happening, there seems to be a pattern developing where we're shifting away from this multi-factor test that the court used to particularly appreciate. And I think there were certain former members of the court who really appreciated these 12-part tests. And we're shifting away from that. And now it's like, okay, well, these aren't boxes you check and then move to the next analysis. They're perhaps useful pieces of analysis, but then you still have to look at everything holistically. And, I think we saw that in Bruin a couple terms ago, and I think we're starting to see a lot more of this shift away from the factors as being just a checklist to just a more holistic analysis, which is, you have 12 parts. It's still going to be whatever the judge wants it to be. You have this analysis where it's like, oh, well, it has to be, each of these different boxes you check off. Well, it's still, I think, going to be, however the judge sees a particular case kind of coming out, they're just going to see those factors and say, well, here's some, here's another, and be done with it.
But the funny thing is that in some ways is rejecting some of these multi-part tests that we had that we still have, but it seems like some people in the court were into for a while, especially, it seems like O'Connor, Kennedy, Souter, maybe I'm being a little unfair there, but they were more into that kind of thing. But at the same time, I think
Breyer was too. I'd add him to the list.
Well, that's a good point. But at the same time, this holistic approach, that's very much a Justice O'Connor thing. Where you look at all the facts, common sense, right?
Yeah.
But it's also to some extent saying a holistic approach. I don't know if it's rejecting is the right word, but it seems like it's a little bit rejecting Justice Scalia's view that you need these bright lines, and the rule of law is a law of rules, and we need a line here. But this kind of situation, maybe he would have agreed. This kind of situation doesn't lend itself to a line other than coercion, non-coercion. But figuring that out, it's just, you got to look at the facts.
I think it's exactly along the same lines as what Gorsuch is talking about when he is saying, when you look at the facts, you have to look at them holistically. You can't just say, oh, this guidance letter doesn't count because we issue guidance letters like this all the time. So in Gonzalez, for example, we have a newsletter where in the newsletter, a city official is saying, here's one way to ensure that the person on city council is removed from the city council. You can convict them, and you can say, oh, it's just a newsletter, right? And it doesn't really call to action or anything. But if you look in this newsletter in context of other things that they do, then it's like, holy crap, they're actually laying out their plan in there. And Gorsuch is saying you have to look at these pieces of evidence together, not debunk them one by one. And I think it's exactly along the lines of what Diana is pointing out in terms of these kind of multi-pronged tests. It's again like, no, you have to look at it commonsensically rather than kind of mechanistically and say, you didn't check every single box, therefore, that's kind of something that robots perhaps would do. But as humans, you see, we're able to go deeper than that.
Yeah. And I wonder if like the checkbox approach is like just a kind of a security blanket for intermediate or lower court judges where they, these can be hard questions and they don't really know kind of what the right way is. And it's like, well, I've got 12 boxes I look at and then I go through each of them. And now it is 8-4. Therefore, the plaintiff wins or therefore the defendant wins. And it's almost an easier way to get there. But it's just like putting your blinders on and missing the forest for the trees. How many metaphors can I mix in one sentence?
Yeah, a multi-part test, if it's not exclusive, like where you need all 5 to go a certain way, like I get that, right? That's not like, convicting someone of a crime, all the elements. But when it's just, well, you look at these and you look at these, I don't think there's anything wrong, fundamentally wrong with that, but it really is just a way of focusing the mind on what's important. But how you weigh all that stuff, that's just common law judging.
Right.
And that's how it's going to come out in the end.
And that's why Adam Unikovsky is wrong in his article when he talks about, like, we might as well go ahead and have AI judges.
Can you say anything more about this article?
Just kind of...
We will try and link to it in the show notes.
It just goes to this idea of, balls and strikes. And in broader concept, it 100% makes sense. But balls and strikes are not that easy often to call because you have all these different shades and undertones and contexts to everything. And last I checked, AI hasn't reached that ability yet, so...
Well, but Judge Newsom in the 11th Circuit just wrote a concurrence using AI. So maybe for the first one, perhaps, of our future. I don't know.
I'm, common law judging people. We're not friends. Okay, America, come on.
Well, Diana, I know you're a fan of robot umps. So
sometimes.
Okay.
Not all the time. I mean, look, now that Angel Hernandez is no longer a Major League Baseball umpire, I think there's perhaps less of a need for robot umps than there used to be. But no, it probably is fair to shift over to a robot ump model. Anyway, I've interrupted. I'm sorry.
No, that's fine. I was going to try to shift to if there's some kind of AI technology can tell us when we should allow proceedings to be ongoing during an interlocutory appeal.
Well, rarely. Never. Interlocutory appeals are tough because they just, especially when they stay the lower court proceedings. And so it's something
for non-lawyers, interlocutory appeal is where you have something going on in the trial court and there's a ruling, but the case isn't over. There's no final judgment, but there are grounds for whatever reason to appeal. And so you have an appeal on that ruling, but the rest of the case is still kind of there. And so sometimes it goes forward, but sometimes it doesn't.
Gonzalez is a great example of this, right? So we are at the motion to dismiss in the case alleging that the 72-year-old councilwoman was arrested because she opposed powers that be in her small town, and they invoked qualified immunity. That's a very good example of the kind of a doctrine.
Common interlocutory.
Yes. Yeah. And so we had claims against the city of Castle Hills, and we had claims against the mayor, the police chief, and the special detective. So the city of Castle Hills can't invoke qualified immunity because they are going under this different standard standard called Manel. But the police chief, the mayor, and the special detective invoked qualified immunity. And as a result, everything is stayed. We were essentially appellees in the Fifth Circuit arguing why qualified immunity should not protect the individual officials. And then the Fifth Circuit ruled against us, and we petitioned for certiorari in the United States Supreme Court. We launched the case in September 2020. That's when we filed the claims. We're still at the motion to dismiss stage. And because of this interlocutory review procedure, it is now June 2024. And they haven't even answered their complaint
And you
yet.
probably could have had a full trial against the city if that portion hadn't been stayed.
That's exactly right.
Whether it should or not is a different question. But, I mean, that's the amount of time we're talking about.
And circuits disagree on whether, by the way, Manel claim can proceed or has to be stayed. In the Fifth Circuit, the practice is that it's stayed, but there are other circuits that would allow you to do it simultaneously. But think about the burden that plaintiffs have then, paying lawyers, doing appellate work and then paying lawyers doing trial work. I mean, unless you are a corporation, you can't really afford to do that. So practically speaking, it's all stayed.
And Diana, you think more broadly, staying is wrong?
I mean, I think interlocutory appeals are problematic, but like particularly the staying aspect of it, because for the points you've just mentioned, it's Sylvia Gonzalez. It filed the case almost 4 years ago, won on the motion to dismiss, and yet there's been no discovery, there's been no summary judgment, there's been no trial, there's been absolutely nothing to resolve the case on the merits. It's now just gone up on the papers for the lawyers to fight over whether these officials have qualified immunity, whether Sylvia could have been arrested in the first place, and basically whether her complaint is adequate to get to the rest of it. And, I understand there's multiple interests at stake here, right? Like there's the need to protect government officials from going through these case proceedings where, at the end of the day, they may be found to be immune or in any of the variety of the different immunity contexts. And so then they would have had to sit through trial and everything. But when you ask, which party is better equipped to handle that, it's obviously the government, because Sylvia Gonzalez has top-notch representation for free by a firm that is spending hundreds of thousands of dollars as a low estimate. And she's able to get that, but very few people are able to get that. And so a normal kind of run-of-the-mill person is going to have to pay an attorney to do all of this before they can even get to the good stuff of the case, and they're not going to be able to do that, or they'll end up having to accept some kind of low-ball settlement figure, or it's going to bleed them dry if it's a case about their business, for example, and they just can't afford 4 years or however long it takes to continue fighting. They end up just having to close shop and do something else, and that's a real shame, because they are not the ones who can afford to carry that cost. The government can, and yet the government is the one that doesn't have to.
What we're learning. So, Dana, you have this case in Texas right now, and we've had another case in the Texas state courts where it seems that it's not just qualified immunity. It's all kinds of kind of random stuff where the cities can do these appeals that just kind of put everything on ice, even though it seems like they're not really about anything much. What is going on there? I mean, you don't have to talk about your specific case,
I'm happy to.
Okay. But how does that even work?
So the Texas, so this is in Texas State Court, which is within the Fifth Circuit, but it doesn't go up to the Fifth Circuit because we're not in federal court. The way the statutes are written, interlocutory appeals are available in narrow circumstances, and of course, one of those circumstances is when the government loses a motion to dismiss. And so in Texas State Court, it's called a plea to the jurisdiction.
So even with no immunity or anything, it's just a normal, like what we call in federal court 12b6 motion to dismiss. The government can appeal that when it loses.
Yes.
That's pretty nuts.
Yeah, it is. So in my particular case, I represent a businessman. That was my example that I used a few minutes ago because it rings true. And he bought a property to open his auto mechanic shop. This has been his dream to own his own shop for basically his whole life. And he'd been leasing for many years and was able to save up money to buy a shop. And he was so excited about it. He bought one that had been used for literally decades as an auto machine shop, which is where they repair engines for racing cars and things like that. I don't know anything about cars. I know how to fill up my tank, and that's about it. But anyway, so he bought this property. He was so excited about it. And he went to get the certificate of occupancy, and the city was like, well, actually, you can't. You need to add 23 parking spots. And he was like, what are you talking about? There's, 5 spots in front. That's more than enough. I don't understand. And they're like, nope, it's not enough. We've amended our ordinances. You need to add it. So there was a lot of back and forth. We sued, and we got what's called a temporary injunction. And which means that the court said, yep, you're right. His constitutional rights were violated by this particular ordinance. He can open while the rest of the case is pending. And so I think his chances are so good of winning that we're going to let him open. And then you can finish the rest of the case, and then, we'll all be done here. And so after that was entered, the other side appealed that decision, which is another thing that they can take an interlocutory appeal of in Texas state court. And then they settled the case. They said, okay, we see the writing on the wall. We're going to let you open. And so they settled for a handful of spots. We dismissed the case. Everything was hunky-dory. That was over 2 years ago. He's still not open today because they have gone back on their word. And so when they said, actually, yeah, sure, you can open, they apparently didn't mean it at all. And so he is first-generation American. He's an entrepreneur, and he is continuing to be forced to lease a property so he can keep his business going and pay for the loan on the property that he bought 3 years ago. And so it's outrageous. So when they went back on their word, we filed a second suit against them, raising new constitutional claims and a breach of contract claim, which I had to dust off my contract knowledge. I haven't used that since law school.
Yeah, because a settlement, that's just a contract.
Exactly. And so, we've got, I think, some pretty strong claims there. And the other side, once again, filed a plea to the jurisdiction saying that they are immune from the case. And so they say that they're immune from the contract claim because as the government, you can't demand money from the government in a breach of contract claim, which is bananas, because why would anyone ever enter into a contract with the government if you can't enforce it? That's absolutely bananas. And there's a whole bunch of case law saying it's bananas.
I'm sure just normal vendors who sell, some bananas to the city cafeteria and then they don't pay for the bananas, they can go to court and get that money.
Yep. Because that's how contract law works. You don't get a special, I don't actually have to follow the contract requirement just because you're the government. And so the trial court agreed with us that there was this claim that they were immune under the breach of contract, and they also argued they were immune under the constitutional claims, which again, there's a whole bunch of case law saying you can sue the government for violating your rights in the exact way that we are suing the government for violating our clients' rights. And so the judge kind of scoffed at them and repeated about 5 times at the last hearing that he thought it was bad public policy what they were doing, and he was going to deny their plea to the jurisdiction. Well, then they've now taken appeal, and so everything is on hold at the trial court. We can't continue until the appeal is resolved. There's a bunch of case law in our favor. I suspect, I'm fairly confident with our ability to succeed. But it's going to take months and months, maybe even years. And if they lose at the Court of Appeals, they're probably going to file a petition for review at the Texas Supreme Court. And they're just going to keep drawing it out because to them, that is the benefit. They just want to bleed a client dry. And, they can.
Yeah, that reminds me of my corporate law days. One of my first clients was actually a printer company, and they sued a school district in San Antonio because for breach of contract, and that school district used exactly the same arguments in terms of government, and we can't be sued for the breach of contract. And again, this printer company had a lot of money and had no problem proceeding with the lawsuit and eventually winning the case. But if you are not a huge corporation, or if you are not lucky enough to be represented by a public interest law firm, those kind of arguments are a big pain in the ass.
Was there an interlocutory appeal? in that printing case?
I don't know, because I actually left the company before the suit continued.
Understood.
And a further wrinkle in Texas is that when you petition for review at the Texas Supreme Court, the court can order merits briefing before the court decides whether to actually grant review of your case. And so they do this a fair amount. In fact, I think this is like their just standard practice. And so it may be the case that you have to pay your attorneys to file merits briefs, and then the court's like, hey, you know what? Never mind. We're not going to hear the case. And so it's just that's expensive. It takes a long time to write a good brief, and you're forcing people to pay. It's like all of this has to happen before my client can go to trial and demonstrate that his rights were violated, and that's ridiculous.
Yeah, the problem is if you approach a small town lawyer, right, and you say, hey, can you represent me? They're just going to say, no, you're fighting the government. The barriers are simply too high. I just can't afford to take this case. If you're suing a private company, yes, I'm your man. Let's go. But if you're suing the government, and I have to fight all these things before we can get to the merits, no way. So that's kind of plaintiffs can't even find lawyers to represent them in these types of cases. That's the fundamental problem.
So this is real. This rule in Texas really is just absurd. Although I'm sure that the County and City Lawyers Association loves it. Have you heard of that elsewhere? Is it just like a weird Texas thing? I mean, qualified immunity is bad enough, but in like where I have practiced in state court, I have not heard of that, luckily. So I don't know if it's like common, but maybe there's other, absurdities like that out there.
There might well be. The federal court system, apart from qualified immunity, doesn't really have that. Although you can take what's called a 54B judgment and basically get the court's permission to take an interlocutory appeal. Which seems to me to be a little fairer, because then that way to do that, basically you have to file a motion and ask the court's permission if a final judgment has been entered against one of the claims or against one of the clients. And so then that person can kind of slice off from the rest of the case. You have to ask the district court first, and then you also have to get the appellate court's permission basically to do it. And which means that they don't do it very often. They don't want these piecemeal cases.
And frequently the other side will agree.
Right.
With a 54B, because they know this is kind of the whole ball game, and let's not waste a trial. And it seems like that's also true with preliminary. So you had the temporary injunction in Texas, and a lot of the times in other states and federal system, you have preliminary injunction. Like we file appeals from denials of preliminary injunctions all the time. We also have the deal where we win and the other side appeals. But I think both sides there kind of often realize we don't need to waste our, like either the plaintiff has the injunction, so they're happy, or they know that this is going to kind of take care of most legal stuff anyway, so we might as well appeal. That's very different than just appealing a pretty routine, part of the case, which is like a 12B6 denial. Right.
Or plaintiffs aren't happy because appellate courts are now, and trial courts are now starting to wind down, perhaps, their use of the universal injunction, which I know might perturb certain attorneys.
And before we, let's not lose sight of how broad qualified immunity is on interlocutory review, right, in federal court. And it can be in state court as well. But what you are doing in qualified immunity posture is you're determining, A, whether the plaintiff alleged a constitutional violation, and B, whether that violation is clearly established. So as a result, in the Gonzalez case, for example, we're not even arguing about the actual heart of qualified immunity, which is whether or not the violation is clearly established. We're actually arguing whether we stated a claim for violation of the Constitution. And the district court said we did. And they were able to take that up in the qualified immunity posture.
Right.
And now we are fighting over whether we stated a claim, even though the district court said we did.
Yeah. I don't know the data on this, but I suspect that qualified immunity interlocutory appeals are made more difficult for some government officials with the use of body cams. And so now there's video. And so the courts have been relying on these videos, which I don't know like how that actually intersects with reviewing a 12b6 motion.
That's kind of our petition for certiorari just got denied in a case that kind of raised that issue, Paul Reese versus Mark Tolf. And the Eighth Circuit looked at the body cam video and said, you know what? Your client did not comply with the orders of the police officer, so you did not state a constitutional violation. And here's the thing. The police officer told our client, Cassie, a mother of two boys who were laying on the ground, she was trying to explain to the police officer that they're her 12 and 14-year-old boys. The police officer said, step back, step back. And the video cam shows that she stepped sideways. She couldn't really step back because the car was back. So if she were to step back, she would have fallen on the car. So she stopped sideways. And the Eighth Circuit, instead of deciding whether, a case that says you can't hit somebody with a flashlight, clearly established that you can't threaten them with a taser, instead of engaging with that, they actually said, hey, we looked at the body cam footage and technically she didn't comply. So qualified immunity for the officer.
And how did the body cam get into evidence? I can't, or not evidence, but into the record?
It was presented in the complaint. Oh, I'm sorry. This case actually, no. This case went to summary judgment. The thing about qualified immunity and interlocutory review is that you can actually invoke qualified immunity at the motion to dismiss stage, then you can invoke it at summary judgment stage. So the body cam video wasn't registered.
But it was not viewed in the light most favorable to the non-movement, which is the standard, because they're making their own judgment about it.
Yep.
Yeah. Although, I mean, it seems like there have been cases recently, Eighth Circuit perhaps notwithstanding, where appellate courts are saying, look, we saw the video, we see a factual dispute, so we're just going to send it back. It's hard to tell at this point. And when they do that, it seems like that's a good result, because then you're sending it back for the fact finder to determine, what should happen, which, that's the role of the fact finder in the court system.
So in all of these appeals that IJ does, we write our own briefs, believe it or not.
Nice transition.
We have attorneys who have, been to some of the better law schools, and did well, and they do writing. But we've heard that there are times where attorneys don't write their own briefs. Or at least they maybe sign their name, but they get someone else to do it. And this careful observers of legal chatter will know that I'm alluding to a story that came out a few weeks ago about this sometimes happens at the cert stage in opposition to a cert petition, because if you get a big name attorney, the reasoning is if you get a big name attorney to write the brief in opposition, it makes it sound like it's a big deal and maybe it's cert worthy. But if you just use the same Joe Schmo as the name that maybe litigated it below, then it doesn't raise attention. But because you want to do a good job, you hire someone and it's, quote, a ghostwriter. So some people have said that this is not exactly unethical, but maybe a little tawdry. And some people think it's perfectly fine. And where do you come down on that one?
I mean, it strikes me as something that's perfectly routine. Whether that's perfectly fine, perfectly ethical, perfectly unethical. I guess I don't know quite as much about that. But it's super common. I mean, there was a story that came out a few weeks ago about it. Okay, but there's also stories from 2017 about it. There's stories from 2007 about it. Like, this is something that's been going on for a long time, because I think attorneys recognize that there is value in getting someone who knows what they're doing to write the brief. I mean, ghostwriting it's a pretty common experience, both at the Supreme Court and then also beyond the Supreme Court. I mean, how many celebrities are actually writing their own books? None of them. None of them are actually writing their own books. They have people who are whipping them into shape, putting them into structure that actually is useful for a book, and so on and so forth. And It's common there. It's common at the Supreme Court. And the point of writing a bio is to get the petition, rejected, right? Like there's no other point than that. And so if you have Paul Clement's name on a brief, for example, the court's gonna be like, oh, well, this is, here's an expert who knows what he's talking about and also has deemed this to be a worthy case to get involved with. Maybe we should take it. And that's, I understand the incentive to do that. And so as long as the attorney whose name is actually on the brief has read the brief and is comfortable with everything that's in it and comfortable putting all of that on their own name and their own signature, then that to me is fine. I mean, that's what our ethical obligations require.
I agree with that. First of all, shout out to Lydia Willer, who wrote that piece for Bloomberg Law. She's got like a very good column on goings on and inner workings of the court, which is always fun to read. So thanks, Lydia. And I agree that I really don't see much of a problem, especially when it comes to the BIO stage, because the lawyer who is ghostwriting this, right, they actually, what often happens with us lawyers is we want to go to the Supreme Court, right? Like it's like a big time show. So you do everything you possibly can to do this. But in these kinds of cases, the lawyers are actually saying, no, I don't want this to end up in the Supreme Court. And I know that putting my name on this will actually make it more likely to end up in the Supreme Court. So I would really rather labor in obscurity and have this petition denied. And I've seen too many times the exact opposite, right? Where you have a petition filed and then respondents actually do want to go to the Supreme Court. And they do everything. It's like a passive-aggressive BIO, right? Where it's like, deny, but really, it's a very important issue, so maybe you shouldn't. And by the way, my name is so-and-so and a very important lawyer. So in those kinds of cases, it's not a true BIO. The kind of BIO that Lydia is talking about here, it's a true BIO. Though I do get, and Lydia quotes some of the experts who say that they think it's unethical, and I can see the other side. But personally, I have no problem with it.
So I agree, unfortunately, with both of you. But I think some of this also is people, especially the legal academic types, big law types who are really good writers and are like, why wouldn't you put your name out there? I think some of it is they don't really maybe know standard practice in just the kind of gutters of legal practice around the country, where this is super duper common. I mean, I was once at this is a little bit round the bend to get to the issue, but I was once at a proceeding where a former lawyer was being admonished. So he was not exactly disbarred, but I think he had his license suspended or something like that. And he was very contrite. I can't remember what it was. It might have been like he just wasn't good with numbers and his clients' accounts or something like that. But so he was being reprimanded and they were like, what are you doing right now? And he said, well, I'm a paralegal at this firm and I'm writing briefs for the firm. And they were like, okay, well, the lead attorney or whoever is actually the attorney on that case reviews your work and signs it. Yeah, I'm just writing briefs for him. And they thought that was fine. Like, these are the judges who are reprimanding him because of other malpractice stuff that he had done. But the act of having, a paralegal, I mean, everyone does this, right? You have a law clerk. They're not like licensed lawyers yet. And yet firms across the country will have a law clerk work on a little bit of a brief or what have you. So this is a paralegal who's not currently a licensed attorney ghostwriting a brief. That this wasn't a brief in opposition at the U.S. Supreme Court. I think it was probably just, state trial court type stuff. But everyone has people, call them lawyers, call them whatever, ghostwrite briefs. So if it happens to be a famous lawyer at a big firm whose name you don't want on there versus your paralegal, I don't see the difference. Frankly. Right. I don't see any ethical obligation.
And you have to think about it from the other perspective too, right? If you do have to add on, the person who wrote the brief or like, do you have to write on every person who wrote the brief, every person who contributed a string citation, like the person who cite checked the briefs, or the person who proofread it and said, oh, I think this definite article should be an indefinite article for it, continuing on the topic of articles, Anya, like, do you have to do that? It's at what point do you draw the line and say, okay, these people have to be on the brief? Because then you're going to have covers that are like 10 pages long, and it's I think unrealistic, because at the end of the day, the reason you have names on briefs and the reason you have signatures is you need someone responsible for the party, for the plaintiff, for the defendant, whoever it is. And you need someone responsible to the court so that if there's perhaps an unethical issue with the brief or something like that, they have recourse against someone's bar license. And that, and if the person who is ultimately signing the brief as the counsel of record at the Supreme Court or wherever else, if they're comfortable with the language that's in the brief, that's got to be it.
And at the end of the day, it's the party. It's the party's brief. There's a lawyer who wrote it and is putting their name to it and has certain ethical obligations and knows a bunch of stuff that the party isn't expected to know. But it's the voice of the party. So
that's very
who cares?
true. Yeah, the court says petitioner argues, right?
Yeah.
Or, Mr. So-and-so argues, and that's petitioner's name. They don't say, Mr. Clement says.
Yeah. So, well, that's enough drama on that issue. But maybe we can turn to some other drama to close. So there was well, it seems like we've had an unending flood of legal drama the last few years. But of course, there was a very famous criminal trial in New York last month that we don't need to talk about at all, the specifics. But it was a spectacle, right? It was a show. I mean, it was not on TV, and then it would have been a much more of a spectacle. But it was, people who are not lawyers paid attention to that. So we got to musing. So me speaking to you listeners now, the three of us got to musing of like other legal spectacles. What makes for a legal spectacle? What is a legal spectacle? Like you hear about trials all the time in the news. You hear about Supreme Court cases all the time in the news. If you turn to whatever section of the paper, if any of you still do that, but it doesn't make it a spectacle. It doesn't make it like drama. But occasionally, like the law world is the leading drama on people that captures people's attention. I mean, the most obvious one of my lifetime, I think of my entire lifetime probably, is the OJ trial that so many of you listening remember. But there's many other examples. Probably the biggest one we have here at IJ, not probably, definitely, is Kelo, when Kelo versus City of New London came out at the Supreme Court. A lot of other aspects of that case that were drama, but that weren't really a spectacle. So, do you guys disagree with how I frame it? Spectacle? Am I missing how to think about it?
What breaks a case into the public consciousness, right? What takes it from a very boring legal case into something that's on everybody's mind? So for me, kind of going through law school is one thing that I remember really well is the Obamacare 1 decision.
Yeah.
Right? And it's about mandates to purchase health insurance. It could be very boring, especially for some people who are not affected by the mandates. But what made it extremely interesting, this healthcare dispute, is one justice is hypothetical, right? And everybody started using it. And that was Justice Scalia, unsurprisingly, and he talked about broccoli.
Right.
Although
that had been bubbling up for like 2 years, that metaphor. To enable him to, say it, and everyone knew what he was talking about.
Yes. And you couldn't turn anywhere without hearing the broccoli hypothetical, right? And it's really fascinating how something like that, an ability to put something in very simple terms, whether rightly or wrongly, can awaken everybody to a very important decision that is on paper very boring, and make it into a spectacle.
I think Obamacare, we forget maybe that the Obamacare litigation, the NFIB case, the actual facts were not super interesting for the average person. Like, I mean, people, you got to buy health insurance now. That's really what it came down to. So, like, Kilo, amazing facts. Woman's house is being taken away. Your case, Gonzalez, amazing. Woman's arrested for just, signing passing a petition
Grandmother
around.
is arrested.
Sorry.
Right.
Yes.
A grandma.
That is an important
Adorable.
fact.
Adorable.
As a person who was representing another different grandmother who was arrested for bogus reasons, that's an important fact.
As the Queen said once, as a grandmother, I understand. Know that I am not one. So, but yeah, Obamacare, like the broccoli gave it. I mean, I think it probably would have run the same course legally the same way if it had not been for broccoli. But broccoli got people to pay attention, whether that's a good reason or bad. I thought it was a pretty good example. Not that government could force people to eat broccoli, but to force people to buy broccoli was definitely, a fair hypothetical. But it broke through in a way that the actual facts of the case were just super boring.
Right. And it's kind of separate from the whole like Sarah Palin thing and, death panels and all that stuff. Like that's a political debate that was happening on the sides at the time. But here we're talking about an actual legal case that a lot of people would read the papers and probably take a nap, halfway through. But when Justice Scalia asks this question, then everybody all of a sudden can frame that case and it will mean something to them one way or another.
Yeah. Right. And I think that's a good point that like if you can distill from a particular case down a couple of facts, those facts I think end up being images that people can put in their heads and they can understand it. So with Suzette Kilo, it wasn't just a house, it was a little pink house. With OJ, it was, at least in my mind, that leather glove that didn't fit, so you had to acquit.
Or convict. Which one was it?
Well, he died not in prison.
You must quit.
Hanging chads in Florida. I
Yes.
wasn't, in law school at that point yet. I'm not that old quite yet. But I'd never heard of a hanging chad before, and all of a sudden it's in everyone's consciousness what a hanging chad is.
Although that was more for the obviously it was who's going to become president. Is that more for politics or because it was in court to some extent?
Maybe both of them. It's and then you've got the like particularly gruesome murder trials where like Casey Anthony and that poor little girl, and I was just in trial a couple months ago in Idaho, and at the same time our trial was going on, which was about a tiny house on wheels, there was a really gruesome murder trial going on about a woman and her new husband who killed their children. They've both been convicted. I'm not defaming them, and there's just these like really gruesome facts that come through that people kind of you think about, and then you like see it in your mind like viscerally, and it's really upsetting. And I think that's why they make so much news. I mean, there's another Idaho murder trial that's about to start, and that one's got also some very striking visuals. And we'll just have to see as they come out. It
seems like often it's the unexpected contrast, like, a huge one that maybe you guys are a little young for, maybe not, is the whole John Benet Ramsey story.
I was in Colorado. I know John Benet Ramsey's story.
And that was because it's a little girl, and she had this story, beauty pageants, and then they don't charge whoever they were charged eventually. I know it was one of the parents they were suspicious about for a long time. And that just like kind of that is not the cookie cutter murder trial. And so that brings it to the public consciousness, which of course, OJ had that in like gargantuan amounts in all kinds of ways. And so you couldn't write a bigger kind of script for how the OJ thing happened. Partly, I think, because of the whole police chase, setting it off. That was just like pouring gasoline on what already was going to be a big story.
Yeah.
How about having big lawyers, celebrity people argue? I'm thinking about a specific case, Amistad, right? The slave ship case from 1839 that was argued in the Supreme Court in 1841. And whom did the public interest lawyers recruit to represent the freed Africans, right, who were forced to be slaves? John Quincy Adams, right, a former president, at the time representative in the House of Representatives, making that argument before the United States Supreme Court. By the way, 8 hours.
Wow. Almost as much as Obamacare.
Yeah, there you go. Anya, how long did yours stretch for?
Like 31, because I had 25 minutes that were given to me, 5 minutes the government took, and then there was a seriatim.
Right.
So they're longer. They last a bit longer now than before the seriatim, when every justice gets to ask a question.
But not quite 8 hours yet.
Not quite 8 hours, but you never know. You got to get the right case in front
Would
of
you
them.
welcome an 8-hour oral argument, or would that just be just no thanks?
And by the way, John Quincy Adams wrote in his diary that, and it was, 2 sessions, 4 hours each. And he wrote in his diary that the entire 4 hours, everybody was engaged and following his legal analysis. And I'm thinking, something tells me it's not true.
He won, didn't he?
Yes, he did.
Yeah.
Yes, he did. And it was the Taney Supreme Court, right? Dred Scott Supreme Court, essentially. And Joseph Story wrote for a nearly unanimous court. Only one justice dissented. And he basically said, these guys are not slaves. And they were never slaves. And in Spain, the slave trade is outlawed. So what the hell is going on?
Yeah.
These guys should be able to go to Sierra Leone.
So that's a former president, of course. Media environment, very different at the time, but I think some of the same principles apply. But that's pretty rare that you have a former president, someone of that stature arguing. I mean, we know some famous lawyers. Some have been on IJ podcasts. We love them, but they're not quite, the level of, I don't know, Bill Clinton arguing a case and the news that would create. So it might be pretty singular example, I guess is what I'm saying.
What if you have somebody like David Cole arguing on behalf of the NRA? I think one of the things that really brought the Vullo case that we discussed earlier today to public's attention, and I'm not saying that everybody knows Vullo, but something that really made it worthy of, Adam Liptak writing about, was that it was David Cole, a head ACLU lawyer writing on behalf.
We love some of David Cole's work, but I don't think it's so much him. But it is because ACLU really is a household name.
The ACLU, 50 years ago, the ACLU represented the Ku Klux Klan as they wanted to march through the streets of Skokie, Illinois.
I think it was neo-Nazis.
Neo-Nazis. Okay, well, tomato.
But that's what brings it to nation's consciousness, right? This idea that ACLU would actually defend somebody like that, because then it shows that the principles are universal.
Right.
Or Ted Olson, wasn't he involved in the Windsor litigation, the same-sex marriage?
And that definitely helped that effort, that he was involved with that. But I mean, bless him, he's not the same level as a former president, former Solicitor General.
I mean, I have a difficult time picturing any of our recent presidents as up to their
Barack Obama.
up to their
I call on
enough.
you if you're listening.
I don't think he'd want to touch that with a 10-meter cattle prod. But. Well, I guess that's all the spectacle we have. But Anya, prediction. When the latest prediction, when your case is coming out?
Thursday.
You don't say which Thursday.
The 13th. Oh boy. Thursday the 13th of June. That's my prediction.
Okay. Diana, do you have any better information?
No.
Okay, just checking. Just checking.
I mean, it's by the end of June, I suspect. with July 4th is on a Thursday this year, so that does make going into July challenging, even though the court has in recent years gone
Well, the
into
last
July.
week they start doing Wednesday, Tuesday, whatever day.
And like 9 a day, just like take your opinions and go. I want to go on
Essentially.
vacation.
Well, we'll see. Listeners can hold you to that. We'll leave it there. Thank you both very much. Thank you all for listening. And, until next time, that's just like your unpublished opinion, man.
I'm gonna do like a Chinaman, go and get some hops.